federal court in the U.S. has ruled that Google has an illegal monopoly in search and has abused its market dominance to quash competition and stifle innovation. Our guest says the decision was actually more forceful in favor of the U.S. Department of Justice than expected and could affect other antitrust cases against big tech companies, including perhaps Apple, Amazon, and Meta. We are joined by Rebecca Haw Allensworth, Associate Dean for Research and Professor of Law at Vanderbilt Law School. Thanks very much for coming on the show. Really appreciate it. Could you just briefly remind us what the court decided against Google?
So the court found Google to have monopolized the search market. That has two elements. One, they had monopoly power. So they had a huge share of a well-defined market, namely search. And two, they engaged in exclusionary practices to maintain that dominance. In particular, paying companies like Apple billions of dollars a year to be the exclusive default on iPhone and other devices.
And we've heard, it's 20 billion a year, according to one report we've heard. Now, interestingly, the court adopted a fairly broad definition of monopoly here, didn't they, or monopolistic practices? Can you explain that?
Well, they were asked by the government to follow the Microsoft decision. This is a very important case, the most important case before this case from the early 2000s. And they really did that to a T. I don't know if I would call it broad, but okay. I would say the government really got everything that it wanted, namely saying, look, these deals are de facto exclusive, even if they're not technically exclusive. And it's unlawful to pay Apple and other companies like that a bribe, essentially, to keep your competitors at bay, to keep them from getting the scale they need to really compete with you. It's a very strong win for the government.
So could it, in fact, turn out that these payments, these sweetheart payments that Apple gets from Google, could they be outlawed?
I think that's probably the most likely remedy. Some people are excited about the idea of a breakup. I happen to think that's very unlikely in this case. You know, as strong as the win was for the government, the case is also very careful. It really hews very closely to existing case law. It's really not out there. I think a breakup would be out there. More likely is what you mentioned. So maybe having a injunction against Google from engaging in these kinds of contracts. And I think maybe the result there could be something like a choice screen on devices or something to allow other competitors to get in front of consumers in some way.
Right. So you would, if you were, say, using Safari on an Apple device, you would get an option every so often. Hey, do you want to switch browsers?
I think that's possible. I mean, of course, the court can't order Apple to do anything because this case is against Google. But I think it could tie Google's hands in a way that made it likely that that's the best way for them to comply. But it's really speculative at this point. We don't know. The judge has been very careful not to tip his hand as to what he thinks would be an appropriate remedy. And there's going to be a whole set of hearings and a whole nother proceeding on that very question.
One thing I'm not a great tech expert, but it strikes me that Google hasn't come up with anything new in years. I mean, they've given us wonderful products like Google Maps. It's a life changer, but innovation was an important part of this case, and Google has been accused of stifling innovation in the industry as a whole.
To me, this is the most important part of this case. So for years, big tech has been beating this drum, saying that antitrust enforcement stifles innovation. And if you want to have a strong, innovative, robust economy, you'll leave us alone because we, Google, Amazon, Apple, are the innovators. And if you use the law against us, we won't be able to give you all the tech products that you like. I think this case turns that argument a little bit on its head and says it's not antitrust enforcement that's standing in the way of innovation. It's the monopolists. And in fact, there's a whole other source of innovation that is not really possible in markets like these. Innovation from little guy competitors, upstarts, that's being sort of systematically suppressed in cases like this.
I know critics have said, well, these big tech companies, they just buy up upstarts who might spoil their party. But of course, a lot of the entrepreneurs who start these companies would love to be bought out by big tech. So I guess it's a tricky one.
Yeah, I mean, that's right. Obviously, that's what the innovators are looking for. The problem with that is that it just doesn't get us the full value that we could get from a truly competitive environment. If all you're doing is building something that Google wants, you're not building anything that would directly compete with Google. That's a big problem.
So it distorts the so-called ecosystem, I suppose. Yeah, we're very tight for time, but the court said using practical indicia, I'm not even sure if I'm saying that right, but practical indications of monopoly rather than simple economic criteria, Google was a monopolist.
So this is a little bit inside baseball, but it's so important in the law. For years, for the last 40 years, there's been a real trend toward forcing plaintiffs to use econometric evidence and models to prove markets. And the problem with that is often that data just isn't present. And if you dismiss a case because, hey, you didn't have an economist in a lab coat to tell you what the market was, you're dismissing a lot of cases that are about common sense markets that we all engage with every day. That practical indicia from a case called Brown Shoe is a way of doing that in a common sense way. It allows the plaintiff to make their case without data that they just can't have. So that's a really big win to see that case come back out and to see that method for defining markets come into favor again.